go in and check on him. Perhaps if she had checked on him, this would have been discovered sooner.
Didn't go in and check on him for what period of time?
Like I said, I'm going to say it would have been between 4 and 6-ish. It's a 911 call, was at 6:12.
So possibly for 2 hours, she didn't check on him.
Yes, sir.
And so is it placing the mattress over the pack and play, or the not going in and checking on it?
Judge, I'm gonna object. She's already answered the question as to why she was charged with child neglect resulting in death.
Your Honor, I think it's a fair question to ask exactly. There's 2 details been given. I'm about to ask about the 2 details, and I'd like to.
I think it's a reasonable question.
Is it the placing the mattress over the pack and play, or the not checking on him for
Judge,
2 hours?
For the record, I want to clarify my objection. I don't think that there is anything in the statute that requires it to be one specific cause.
Well, I think both could be a fair answer. I mean, she needs to answer the question.
Yes, Your Honor.
You understand the question, right?
I do.
What's your answer?
I would speculate that ultimately the placing of the mattress over the playpen is what led to his death. You know, she did also tell us that she had heard him crying for a while and then he stopped. So, you know, a reasonable person may have gone in and checked just to make sure he was okay at that point when the crying stopped. Or, you know, maybe she would have discovered him before this happened.
So that might have happened, or she could have done that, but does that mean that you're able to make a judgment as law enforcement that it was unreasonable to not check on him?
Again, Your Honor, I'm going to object. It calls for a legal conclusion. I think that she has answered why if this was charged the way it was charged. I think the facts have been testified to are clear as to why it was charged the way it was charged.
Mr. Sullivan.
I'll withdraw the question. Is there any evidence at all that Ms. Napier intended to harm the child?
Judge, I'm going to object. Intent is not an element of this offense.
I agree. I don't think the intent is not part of this.
Your Honor, okay, I'll withdraw the question. To your knowledge, was Ms. Napier taking proper care of the child before this incident happened around 4 o'clock on July 11th?
Your Honor, I'm going to object again. This does not, anything that pertained to what she did before does not pertain to why she was charged with the crime that occurred.
Your Honor, I think if my client was taking care of a child, reasonably taking care of a child, it goes to the totality of whether her care of this child was reasonable.
Your Honor, again, I don't think it's relevant to whether or not she was acting reasonable at the time of the offense. Just because someone acted a particular way in the past doesn't mean they're acting the way at the time of the
I
offense.
agree. Detective Powell, you're not going to answer that question.
Yes, sir.
You spoke to Ms. Napier about, well, did you actually interview Ms. Napier?
I did on July 17th.
And there were other officers who interviewed her at other times?
Yes, sir.
And was this interview where did this interview take place?
Kanawha County Sheriff's Office headquarters in an interview room.
So it was recorded, right?
Yes.
Okay. As were all her other interviews, right?
Yes.
She told you why she had placed the mattress over the crib, right?
Yes.
Okay. And what was the reason she did that?
To keep him inside because he could climb out.
And was she asked whether she thought that was a good thing to do or a reasonable thing to do?
I don't remember if that question was asked.
Was she asked why she didn't go into the room between approximately 4 and 6 o'clock?
I just remember her saying she thought he had gone to sleep.
So, the baby was crying, she put him down for a nap, she heard him crying for a while, and then she didn't hear crying anymore.
Yes, sir.
And she thought he had gone to sleep.
Yes,
Okay. And that's what she told you, right?
yes.
Okay. And eventually, after some time, she asked her other child, and how old the child are we talking about that went and discovered the baby?
Juvenile, but not a teen. I think he's 10 to 12.
Okay. So at some point, she asked that child to go in and check on the baby.
Yes.
What were the actual injuries to the baby, if you know?
I observed his injuries, so, on the front of his neck, just very centrally located, pinkish purple. I don't know if I would call it bruise, if I would call it compression marks. He also had, just small circular bruises on his forehead, and just some other, small bruises on other places on his body.
If you are aware, was there any attempt to, well, actually, I guess the first question would be, do you know if the baby had passed away before paramedics had arrived, or was it after?
He was already passed away.
As far as you know, had he died before the 911 call? And I'm not
It's
gonna
had a
ask
medical
you,
opinion, but
if you don't know, you don't know, that's fine.
I know that, I know the CPR was performed.
CPR was performed by paramedics or by people at the house?
I was told it was by Brittany.
Did she express to you in any way that she was trying to take care of this child the best that she could?
I would say yes, it's a fair statement.
I have no further questions.
Is there anything else from the state?
Just a very brief follow-up. With respect to how long the child had been in the care of the defendant, is it true that you got multiple different answers, not only from other individuals, but also from Brittany Napier as well?
Yes. I think at one point she made the statement he'd been there since like Thursday, but then she looked up some messages on her phone and she said, "I'm sorry, I told you wrong. It was either Saturday or Sunday." And it may have been Sunday that she said he arrived. It was on Sunday. He was supposed to be picked up Tuesday, but then it was agreed upon that she could pick him up Wednesday.
Okay. And that was something that she had planned with the mother of the child, correct?
Yes.
One other question. With regard to what the defendant was doing while the child was in the playpen when he was crying, and then eventually when she said she thought he might have fallen asleep, do you recall her also telling you that she was braiding her daughter's hair and that takes a while?
I do recall her saying that during that time period, that's what she was doing, was she was in the living room braiding her daughter's hair.
Nothing further.
Is there anything else, Mr. Sullivan?
No.
Thank you for your testimony, Ms. Beckett.
Yes, sir.
Please step down. Does the state of West Virginia have any other witnesses they wish to call today?
No, Your Honor, the state rests.
Does the defense have any witnesses they wish to call?
We're not calling any witnesses. Your Honor, I would like the issue of bail to be addressed if there's probable cause found.
If there's no objection to that, I will, pending a finding, I will address the following.
No objection, Your Honor.
Is there a closing statement from the state?
No, Your Honor, I will submit on the testimony. I think the court has sufficient cause to find probable cause based on the elements of the offense and the actions that we've heard described here today.
Mr. Sullivan, do you have a closing statement?
Yeah, Your Honor. You've heard testimony about the tragic death of an infant. And there's no doubt about the seriousness of this matter. But in terms of the law, the question is whether there's probable cause that Brittany Napier was neglecting this child. And I think even with knowledge of the cause of death, which sounds accurate, that the cause of death might have been due to the heavy mattress on the packing play. That doesn't mean that it was an act of neglect. That Ms. Napier was trying to take care of the child, and that she was trying to make a situation where the child wouldn't be out of the playpen so it could take a nap. So I don't think that the court can find probable cause that either the method she used or not going into a sleeping child's room for maybe 2 hours, either of that constitutes neglect under the law. And that's even knowing the way that the baby died and the circumstances that it happened under. I don't know that leads to a finding of probable cause for this crime.
Your Honor, if I may.
Yes.
For the record, the definition of neglect under the code is the unreasonable failure by a parent, guardian, or custodian of a minor child to exercise a minimum degree of care to assure the minor child's safety or health. I don't think that putting a small toddler in a makeshift cage so he couldn't get out is exercising a reasonable degree of care, even a minimal degree of care. Not at all.
I'm gonna find probable cause today. This case will be bound to the grand jury. Now, Mr. Sullivan's made a motion, to address the bond, and we will do that this time.
Your Honor, bail is set at $250,000, short of your 10% cash. That is an impossible amount to make. The question of bail is not how grave the charge is, because we recognize that this is about as serious as a matter can be. It's an issue of whether the person is going to flee the jurisdiction and show up in court. Ms. Napier doesn't have any criminal record. She's lived here all her life. We know that this tragic accident occurred in her home, but that doesn't make her a risk of flight or danger to the community. So I think there should be a reasonable bond set so that she'd have an opportunity to possibly be out of jail while she awaits any further proceedings. I'm going to ask for the amount of $20,000 short of your 10% cash.
I do have some concern with her having children in the home being a charge.
Your Honor, with respect to bond, the state is opposed to any bond reduction in this matter. I do have information that the defendant, at the time of this incident, had plans to move to New York in 2 weeks. So I do have some concern with her remaining in this state. In addition to the defendant's criminal history, which is admittedly, she had a prior domestic misdemeanor conviction, or I'm sorry, that was dismissed. The court is also permitted to take into consideration the strength of the state's case and the nature of the charge. And I think in light of all of those circumstances, as well as the remaining GIS factors, that bond is appropriate as set. But I would ask this court to include a condition that the defendant is to have no contact with any minor children.
Was there anything else, Mr. Sullivan?
Your Honor, she understands that she wouldn't be allowed to move to New York unless the court gave her permission to do so. She would like to have contact with her own child, but I can take that up in circuit court. The fact that this tragic accident happened to a 2-year-old child doesn't make her a danger to anybody else. So if a reasonable bail was set, the court has reasonable assurances that she'd be in court if and when she's prosecuted. And that's what bail is about.
I'm gonna deny your motion today. We'll leave the bond the same. You can make your motion in circuit court.
Yes, sir.
thank you, we're done here today.